going to start one credit course on international criminal law today, which is the MHRE sanctioned GIAN program. So we are very fortunate to have with us Prof Nicholas Tsagourias, who is an eminent professor of international law at the University of Sheffield. So he joined Sheffield in 2002. Prior to that, he was professor of international law and security at the University of Glasgow. And he has a wide range of expertise in the areas of international law, in particular use of force, international humanitarian law, collective security law, peacekeeping, UN law, and European constitutional theory and law, and so on and so forth. He has, Tsagourias has a large number of very quality publications in these fields. In fact, some of them are considered to be landmark in their own right. He also sits on the editorial board for the Journal of Conflict and Security Law at Oxford University Press, and he's also a member of the Use of Force Committee and the Cyber Terrorism Study Group of the International Law Association. And apart from that, he has taught at many universities across Europe and the United States, and also holds a visiting course at the University of Umea, Sweden, at this point of time. He has been very kind to visit us, and hopefully you will end up learning something from him in the course of the next 6 days. Any queries you have in course of the program, feel free to address it to him, and any organizational matter, feel free to ask me. I think all of you have been provided with a copy of the study materials with you. I'll also, he'll be making reference to certain books. They're all available at our library. So you can, they have been frozen, so nobody can issue them, but you can go and consult and take photocopies. So without further ado, I'll leave the floor to Prof Tsagourias, and I'll try to get out of this way for the next 2 hours. Feel free to take advantage of the address as possible.
Good. Thank you, Shubhik, for the very generous introduction. And I'm really excited to be here. It's my first time in India, and also teaching in one of the best universities or best law schools in the country, in India. It's also something I'm looking forward to. So, of course, the course is International Criminal Law, and I suppose some of you have never been taught International Criminal Law, so, or have you done before International Criminal Law? No? Okay. Now there's a lot of material, so it's in the it's e-resources, so you can access them in the library. So you have the handout, and the handout identifies the issues we're going to discuss in the seminar, and also there are some kind of questions. It's for you to start thinking on the questions. So when you do your reading, you kind of reflect and try to answer questions. And I prefer to have a kind of discussion here. Of course, I can direct the discussion, but I prefer to have something of the discussion, because it's the way you can learn by sharing your knowledge and experience. So the first today's seminar, okay, it's a huge seminar, but it's about the development of international criminal law. Of course, it's the latest development, but we go back to the Nuremberg trials. And can you hear me, or is it okay? You hear me? All right. Okay. And going up to the tribunals, the ICTY, ICTR, or the tribunals, or other tribunals. Tomorrow will be on the ICC, International Criminal Court, and then we go to the specific crimes, genocide, crimes against humanity, war crimes, the crime of aggression, and then we consider different modes of liability and participation in the commission of crimes. It's mainly Article 25 of the ICC statute. So, to start with today's seminar, of course, as I said, international criminal law is quite recent development. It's mainly from the 90s onwards that international criminal law has kind of evolved, and now, of course, we have the International Criminal Court. And as the word says, it is criminal law, but it is international criminal law. And then if we start, if you like, explaining all these words, what is criminal law, what is crime, what is international crime, etc., then we can, if you like, understand why international criminal law is a late development. It's from it's part of international law, but it's a late development of one aspect of international law, and also understand the status of international criminal law today. I mean, what it is and how it is international criminal law. So if I mean, you are law students, and so it's a kind of basic question I'm going to ask you. What is a crime? How you define a crime? And then we try to apply that to the international and say, you know, what is an international crime? So what is a crime? I mean, I'm pretty sure you've done criminal law. So how do you define a crime? So you have torts, you have crimes. What's the difference? Both of them are bad, but crimes are worse than torts. So what's the crime?
So like initially the difference could be attributed to the intention of the perpetrator, but lately it has moved on to a difference between what is more grievous and what is less grievous.
Okay, and so more grievous is what? Crime or tort?
It's a crime.
Okay, and why, for example, murder is a crime, whereas breaching a contract is not a crime, it's a breach of contract. Tort, you can pay, you know, compensation, whatever it is. So why murder is a crime? And what are the implications of calling it a crime?
Well, yeah.
Anyone? I mean,
it's considered violence against the society at large, and hence the state is usually prosecuted.
Good. Okay, so it is. Are you people coming still? There are two chairs here. If you want, I don't know. Disappeared. I think you didn't like it. So crime, if you like, is a violation of the fundamental values of a certain society, right? And of course, there are certain common values that, you know, in all societies, you know, they try to protect, because otherwise you wouldn't have it. For example, murder is a fundamental value, because if you don't have people, you don't have states, you don't have societies, etc., right? So it's a violation of the fundamental values of a certain society. So you criminalize that act because you want to protect these fundamental values. And that's the difference, you know, between crimes and torts. What are the implications if you commit a crime, and how they differ from if you commit a breach of contract, for example?
The punishment that we get for crime is penal in nature, as opposed to if you breach a contract, it's more sort of like damages that you need to pay.
Exactly. So it's more serious. So it's afflictive, the punishment. So usually, you know, go to prison, for example. And if you pay compensation, it's criminal compensation, which is not as it is in tort, for example, that you, it's like reparation. So you pay money to restore the situation that would have existed if, you know, that tort is not committed. So the punishment is punitive, all right, and it is afflictive in general. Okay, so it is constrain your personal freedom. You pay compensation, which is in relation to the value that has been violated. Okay. Now, if we apply, there are some chairs here if you want. There are chairs here. So if a crime is the violation of the fundamental values of a certain society, now if we apply that to international to see, what is an international crime, and of course whether you can have international criminal law. So are there any problems with international? So the first thing you have to identify, of course, is the values or the common values of the international. Are there any common values for international? Sorry? Human rights. Was it always? Sorry? Yes, all these obligations, but was it always like that? Was it always that human rights were so important? Okay, post-World War II, etc. Okay, so you see that there is kind of disagreement, or there's no common values, or if there are common values, it's a late development, right? Which explains why international criminal law is also a late development. Okay, so I mean from human rights, etc. So humanity, if you like, in general, may be a value which is common across the board. Of course, there can be different interpretations of humanity, right? But at least as a core value, there may be a certain kind of agreement. And if humanity is a kind of common value, can you think of the main international crimes, the core crimes, the genocide, crimes against humanity, war crimes, the kind of aggression, which one relates to humanity?
All of them.
All of them, apart from aggression and stuff, but genocide is protection of the humanity of certain groups of people, crimes against humanity, the word says everything. And war crimes, of course, is usually violations of the laws of war in relation to certain protected people, right? So the agreement on the fundamental values, which is minimal agreement, right, then means that you have these crimes, but it's the latest development. Is there any other international value that there is a kind of agreement at the international level? We talk about humanity, right? Anything else?
Racial discrimination.
Which goes to humanity. I mean, you don't discriminate someone because of color or sex or whatever, because it's the inner humanity and dignity. But in the relation between states, what is, the value, which is never there, but
Responsibility to protect.
Is it more sovereignty?
sovereignty or peace. Peace, everyone talks about peace. We never have it, but everyone loves peace. So peace among states, in the relations between states, is a value. Okay, there's a kind of common agreement. However, again, this is a kind of latest development, because war was never prohibited, at least until the UN Charter, etc. Any state could go to war, etc. Now, peace is a late development. So there's agreement. Of course, this agreement is what is peace. From the core values, from the core crimes, which one relates to peace?
Aggression.
Aggression, the crime of aggression. Okay. So, the agreement on common values, which is a recent thing, explains as well the core crimes and also the recent development, that the fact that the international criminal law is the latest development. Okay. Now, another problem, if you like, which explains why international law is late development, and also explains international criminal law, and also explains the nature of international criminal law, is that criminal law is about state responsibility or individual responsibility? It's about individual responsibility. Now, are individuals subjects of international law?
No, they can, you can only have attributable offenses that can be attributable to the state. So no individual can be a subject matter of state crime.
It would depend on the forum, and it would depend on what field of international law you're dealing with. I mean, public international law, by implication, exempts itself from state, from individual.
Exactly.
But if you have private international transactions,
Yeah, well, we talk about public international law. So in public international law, who are the main subjects? States. Right. So you cannot have criminal responsibility, which is about individuals, if individuals are not considered to be subjects of international law. And who decides that individuals are subjects of international law is, of course, states. So states need to come to an agreement, right, that says that certain acts are criminalized, and then, of course, you have trials, etc., punishment, etc. And that explains the fact that international criminal law develops through agreements between states. If you take the International Criminal Court, what is the International Criminal Court? It's a treaty, right? States have signed it, and they say that these are the crimes, and then the ICC has jurisdiction, and we accept that we exercise jurisdiction over our individuals. Now, if you are not a party to the ICC statute, okay, you may have certain obligations, customary law obligations, etc., but you are not bound by the ICC statute. Okay, I mean, say the US or any other state, Israel, China, Russia. India is a party, isn't it?
It is not.
It is not. India. So it's not bound by the ICC statute. Sorry?
The ICC statute.
Yeah. So international criminal law develops through agreement between states, and that's why it is fragmented. Okay, and it is, if you like, based on different courts. Okay, so you have the international criminal law of the ICC, right? It's for the member states. 124, I think, states, but for the other, I think it's 192 states in the world. I don't know if you include the Vatican. I don't think the Pope commits international crimes. So, you know, the other kind of 50, 60 states, etc., you know, they're not bound. Of course, then you can have ad hoc tribunals established for specific purposes, but they don't have jurisdiction over states outside or states that have not signed them. Okay, so it's fragmented because states are the main actors in international law, and they decide whether international criminal law should apply to individuals. Now, can states be criminally responsible? Would, you know, states like to be called Politically, yes, you may call them, legally speaking. I don't think any state would like to be called a criminal state. And of course, if criminal law has to do with actus reus, mens rea, etc., you know, how you can say that the state is criminally responsible for a specific act is very difficult, right? Of course, there are ways of doing that, but you cannot take a state to a court and, you know, whom do you take? The president, the prime minister, whoever, and, you know, what was your intention, etc. It's very difficult. And politically, legally, of course, states do not want to be called criminal, right? So states always resisted the development of international criminal law. And if you take these crimes, right, genocide, crimes against humanity, of course individuals are responsible for the crimes, right? But behind these crimes is the state. You cannot commit genocide or crimes against humanity, war crimes. I mean, war crimes is soldiers, it's state soldiers. If the state is not behind that. So for the state it's very convenient, right? They can commit whatever crimes, if you like, and then of course punish the individuals. And the state, you know, it's not, does not have any criminal responsibility. It can have civil responsibility, like state responsibility, which is different, so it's not criminal responsibility. Of course, if you go to the law of state responsibility, I think you spoke about erga omnes obligations or about jus cogens. So it's aggravated responsibility. So if a state, through its organs, etc., commits genocide, crimes against humanity, etc., it doesn't have criminal, but it has state responsibility, but it is aggravated responsibility. It's more serious, if you like, responsibility. So it's kind of in between, if you like, state responsibility, which is like civil tort responsibility, and criminal law responsibility. Okay, so all these things explain, if you like, the late development of international criminal law, and also the nature of international criminal law. Why do we have these crimes? Why do we have these different kind of courts and tribunals that deal with international criminal law? And there isn't any preceding court, right? If you go to the domestic level, of course you have the highest court that makes a final decision, etc. At the international level, you don't have it. So you can have not only fragmented international criminal law, but also fragmented jurisprudence, and then you can have also courts interpreting the law, international criminal law, in different ways. Okay, so that can cause a lot of problems. It's good for lawyers, because lawyers like uncertainty, and then we can interpret the law, you know, do all this. And good for academics, we can write our books and criticize, etc. But not for, you know, the people on the dock, etc. Okay. Having said that, now I'll go back and try to see whether, back to the history of international criminal law, and see whether, you know, we have any kind of precedent in international criminal law. So from your reading and from your general knowledge, are there any kind of precedent international criminal law, like any big trials in the past? I said it's from the 90s onwards. Yes, you have the development, but before the 90s, 1990s, do you have, is there anything, say, in ancient Indian civilization that similar to international criminal law? in general, any precedent, apart from, say, I'm of Greek origin, so the Greeks would say, yes, in ancient Greek, there was, because always Greeks like to say that there was something. What they were doing, they were just, if there was a war, they're just killing, raping everyone, so that's nothing that has to do anything with international criminal law. So the kind of precedents were the trials after
The Nuremberg trials.
yeah, the Nuremberg and the Tokyo trials. So that was mainly after the Second World War. And after wars, you have this kind of cathartic process, and people come to their senses. And so after the Second World War and, of course, all the things that happened, of course, you had the trials, and you had the UN was created, etc. So you have the institutionalization of the international system. And, of course, criminal law is part of the public law. I mean, the domestic system is public law because it's state, it's about the state, okay? And in the international criminal law, it's part of the public international law, it's not private, etc. So it's about the international society, however you define it, is about the morals and the institutions of international society. Of course, the trials, the Nuremberg trials, were this kind of precedents. But before going there, you know, if you go by history and always, of course, you can find something, and then you can say that, you know, that's a kind of precedent. So it's an interesting case because there's a lot of similarities with modern international criminal law, and also the some of the arguments used in trials. So it was the trial of Peter von Hagenbach in 1483. Now, this guy was kind of Europe at the time, you know, was divided into principalities, etc. Okay, so he was the ruler of Reims, which is kind of region in France, and he was a very brutal ruler. You know, killing, raping, kidnapping, etc. people. So then there was, if you like, an alliance of other pieces that they fought, okay, against him. They won, they captured him, and then they put him on trial, right? Does it ring any bells? You know, does it remind you of something? So you have the victors,
Nuremberg.
Nuremberg, Tokyo, of course, you go to Iraq, etc. Okay, so there was 28 judges, and there were those, the princes, etc., that they won the war against him to try him, right? So some of the arguments that he used is arguments that are used also in modern trials. First of all, as any good lawyer does in a court, is to dispute the competence of the court, you know, to deal with this issue. So he said that you cannot try me, right? I'm not your national, etc. The only person that can try me or punish me, etc., is my ruler. Okay, and that, in kind of modern language, has to do also with immunities. You know what are immunities, right? So a foreign court cannot try officials of another state. Okay, Pakistan cannot try Libyan. officer or India cannot try Pakistan because they have immunities, right? It's only their own country that they can try them. So that was one of the arguments that he used to dispute, the competence of the court, whatever court, to try him. Also, he used another argument, saying that, well, what I did, I was following orders. It wasn't on my volition, but it was following the orders of my master, my superior. So, in modern language,
Superior responsibility.
Orders, yeah, not superior responsibility, which is different. It's superior orders. Okay, so if you follow the orders of your superior, then of course the law has changed, so it's not that you are exculpated. You can still have responsibility, but it can be mitigated. All right. And of course, there were certain other arguments that it's what law you would apply, etc. But you see that there are some kind of common traits in the defense from that time to modern time. Of course, what was the verdict? What do you expect?
He's convicted.
He was found guilty. So that was the end of the story. Now, moving from there, one of the kind of big events that caused a lot of problems in Europe was, of course, the First World War. Of course, we had the Second World War, but the First World War was also a very violent war. So again, we had on the other side Germany, then on the other side we had the Britain, France, etc. So there were the winning powers. Now the question then is, what do you do with Germany, right? Do you try those responsible, or shall Germany pay any compensation, reparations for the damage it caused during the First World War? Do you know how they dealt with the issue?
So they signed the Treaty of Versailles, where they gave a lot of things like they gave the mining regions of Alsace and Lorraine to the country where Germans have invaded, and the other reparations were also like they had to give the damages to other countries as well, wherein German soldiers have went and invaded.
Yes. What about criminal?
They were supposed to set up a committee which was to investigate the criminal liability, but I don't think it ever happened.
Okay, so they had a committee to investigate violations. It was divided actually in subcommittees. So one was to see whether any crimes were committed. One was about reparations. The other was about violations of the laws and customs of war. So the proposal of the committee was to try the German Chancellor, the Kaiser, the Emperor, okay, and those responsible for the war. Of course, not everyone was happy with that. The US, for example, and Japan, all the representatives, they said that in international law at the time, the violations of the laws of war are not criminalized, so there's no kind of criminal responsibility for violating the laws of war. But the views of the other prevailed. So this was included in the Treaty of Versailles, as it was mentioned by your colleague, which is the peace treaty at the end of the war. So you have Article 227 of the treaty, which says that the allied and associated powers, which means Germany, UK, France, etc., the winners, international morality and the sanctity of treaties. Okay. So they wanted to prosecute him for offenses against international morality and the sanctity of treaties. Doesn't make any sense to you. Can you try someone for violation of international morality? Is it, I mean, you are lawyers, do you think it's a lot of law there or a lot of wishful thinking? I mean, if you were in a court of law and said international morality, what would you do? Say, pie in the sky. What is international morality? Do you criminalize? How do you define international morality? So do you criminalize violations of whatever it is, international morality? So this is not legal, okay? It's a kind of like moral statement, but it's not legal. And if it was in a proper court of law, of course, this kind of count will fall immediately. Law or criminal law, what criminal law needs to have to be proper? So what are the characteristics of criminal law?
So setting defined terms of a crime and
specificity.
there need to be a specific punishment for it.
Exactly. Okay. Specificity is very important, and of course, the law should be there. Okay. What is called the non-retroactivity, etc. Okay, the law should be there, but not for international morality. The second part, sanctity of treaties. Is it more legal?
But there was no treaty in the first place.
There was no treaty. Were any kind of treaties relating to the conduct of hostilities? There were the 1899 and 1907 Hague Conventions. Okay, these were the conventions about the conduct of war. Okay, the means and methods of warfare. Right, they're still, valid and they apply, etc. So it's basic conventions of international humanitarian law, and something which I should mention now, perhaps I should have mentioned before, is that international criminal law is derivative law. Right? It's not primary law, it's derivative. It's the criminalization of certain acts prohibited by other branches of international law. For example, war crimes, okay, are of course criminal acts, but the prohibitions that exist in humanitarian law. So certain prohibitions in international humanitarian law that have been criminalized, not all of them, but for example, killing prisoners of war. That's, but if you don't provide proper sanitary equipment to a prisoner of war, that's not a crime. It's a violation of humanitarian law, but it's not a crime. But killing is a crime, or killing civilian or whatever. Okay, so international criminal law is also derivative. So you have to go back and see the primary law. Now, the primary law, and that's the issue here. Okay, you have the primary law, which is say the Hague Conventions, which was about the conduct of warfare. They included prohibitions. Okay, that you shouldn't use indiscriminate weapons, for example, right? But they didn't criminalize it. Okay, so a prohibition does not necessarily mean that it's also a crime if you commit it, right? It can become a crime through, say, state practice. For example, if national courts start trying prosecuting soldiers, tracked soldiers for using, now they do, yes, I mean it's a crime, but I'm talking now for 1919, right, or 1920 when you had the Versailles Treaty. So at the time, there wasn't any criminalization of those acts. There were prohibitions, but they're not crimes. There were certain other provisions, etc., but nothing about criminal law. Okay, so again, it's like it's kind of grandstanding, right, to say all these things. But if it was going before a court of law, and if the court of law was dealing, trying to establish whether there is a crime, you know, what is the law? Is it certain? Was it there? Did they know it, etc.? All these charges would have fallen. Okay. So that was about the criminal part. Was he tried? I mean, you have it. Everyone signed the treaty. Okay, the Versailles Treaty. Was he tried? The Kaiser? The Emperor? No. What happened to him?
I think Netherlands or someone gave him refuge.
Yeah. He went to the Netherlands and the Dutch didn't extract him, so he lived happily thereafter. That was about the Kaiser. What about other officers, say, or German officers, that they committed crimes? Were they kind of tried, etc.? Yeah. By who?
There were state trials. I think the state
Yes.
was supposed to hold trials.
Yes. So it was by the Leipzig. Leipzig is a city in Germany. So it's the Leipzig courts that they were trying the German officers. And that shows as well that international criminal law is complementary to state action. Okay, so it's primarily the state that needs to take action, prosecute and try people, etc. The primary responsibility rests with the state, and then the international courts, etc. They have complementary responsibility, and mainly can be responsibility for the big fish, or fishes, if you like. Okay, the big names, right? So for smaller fish, you have the national court. So you have the Leipzig courts. Did they kind of find guilty? All of them? There were 900. No. So it's only between 10 and 20 that they were found guilty. All the rest were acquitted. Now, whether that was symptomatic, that was real, or the trials were not proper trials, etc., because of course the state at the time, does not want to try its own officers or its own people, because the state relies on them, right? Of course, there is an obligation for the state to do it, and of course, the state should do it, but then you have to think of all the other policy requirements there. And usually states, I don't know about India, but if you take UK, etc., they may try, or the US, they may try, but perhaps the penalties are not as severe, or they can find other ways as not to bring the case before a court. So that was about the criminal responsibility. What about any other kind of responsibility for Germany to pay reparations? So Germany was also responsible to pay reparations. And some may say that that was a kind of criminal damage reparation, because they were very, very heavy reparations. So that's Article 234 and the rest of the Treaty of Versailles. And that caused a lot of problems in Germany. And you have the rise of the Nazi Party in Germany. The whole, if you like, discourse and of the Nazi Party was against the Treaty of Versailles. Because of the reparation Germany had to pay, that caused a lot of the German industry, etc., was controlled by the Allies. They had to pay a lot of money to the Allies. That there was not enough money, for the Germans. There was unemployment, etc. So there you have the rise of the Nazi Party, and of course you had another war. But those kind of reparations after the First World War, someone may say there are criminal reparations. And it's as if Germany was found to be, as a state, criminally responsible. And if you read the article, it says that Germany accepts its responsibility, etc. Of course, that was decided for Germany. Now, do you want to have a break? Because we then go to discuss the Nuremberg and the Tokyo tribunals, and then move to the more recent tribunals. Do you want to have a kind of 10 minutes? How long do you want? I don't know. I mean, for me it's very warm here. I'm not going to faint, but it's quite warm. But do you want to have 10 minutes break? 15 minutes? 10. Right. Good. So 10 minutes break. So we come back just before 5. Well, welcome back then. Now, if you have any questions, please feel free not to ask. Raise your hand and ask. If you have questions, do you mind if we close the door as well? There are people coming. Okay, so if you have questions, feel free to ask, right? It's the way we learn things. If you ask a question, then other people may have the same question, so if we discuss it, then everyone learns. Was it easy to find to read the material, to find them, cases, have you read cases, etc.? Now you don't have any excuse, you go to the website of the court and you find everything. It's not like when I was a student. You have to wait for years, for the decision to be published. But so yeah, that's the good things and the bad things of modern technology. You cannot have any excuse not to read the case. Now I see that the post-WWI is for the next seminar. So for this seminar we do the Nuremberg and then about the sources of international criminal law. Okay, so we said with the First World War you have this kind of attempts to try the German Kaiser and German officers. You have the kind of criminal damages that Germany had to pay, then among other things led to another war, and then after the Second World War, again you had on one side Germany, Japan, Italy, and other states, and on the other side you had the victors, the US, UK, France, Russia, the Soviet Union at the time, etc. Again, the question was, what do you do with all the crimes that they committed during the Second War? And one of the biggest crimes was the what's called now genocide. Genocide did not exist as a term at that time against the Jews in Europe. So Churchill, being a very practical man, his view was, shoot them. Just take them, shoot them, end of story. Now the Americans, you know, the New World and, you know, all these things, they wanted to try them, right? Try them because it's an example to show that we are different, right? We are winners, but we are different. We don't do the same things as the Nazi Party was doing. Of course, the Russians wanted to try us, but for the Russians, the price was to find them guilty and shoot them. Okay. But not have these proper trials of representation, etc. Okay. But of course, the Americans won the argument for obvious reasons. They put the troops, the money, and the rest. So you have the tribunals, right? That was established. So you have the Nuremberg tribunal was established. How, legally speaking, with what kind of act it was established? Nuremberg tribunal.
The treaty between the countries.
Yes. Okay. So there was a treaty. It was the London Treaty that was signed first by the four states, but also other states have also signed up to the treaty. Okay, so you have the London Agreement, which was also became the statute of the International Tribunal, the Nuremberg Tribunal. And why Nuremberg? And not Berlin, for example. Berlin was the capital. It's where the Nazi Party started with the big rallies, etc. Okay, so in the 30s, right? So it was very symbolic, if you like. Okay. So you have the Nuremberg tribunals now. The trials, they were divided. First of all, the Nuremberg tribunal would try major German war criminals for crimes that don't have any geographic limitation, right? For crimes committed in Germany, of course by German officials, etc., jurisdiction, it was the occupying powers that had jurisdiction, okay? You know, Germany was occupied by the four powers. So the East, what was in Germany, whatever was occupied by the Soviet Union. Then you have France, UK, and the US. Okay, it was four. It was divided into four parts, occupied by the four powers, etc. Now, the occupiers, according to the law of occupation, which is humanitarian law, which is now the was the 1907 Hague Convention, now it's the fourth Geneva Convention. Occupiers have power to try people for crimes or war crimes. Okay, so crimes committed in Germany by Germans were tried by occupation tribunals. Okay, established by the occupied powers. Now, for crimes committed by Germans in other states occupied by Germany, it was those states that had jurisdiction to try them. So, for example, Greece tried Germans or anyone else for crimes being committed in Greece, right? Yugoslavia, etc., for crimes committed in that state. Okay, so that was the division. So Nuremberg was major criminals for crimes that didn't have any kind of geographic limitation. Now, what was that was, if you like, the ratione personae jurisdiction of the tribunal. But in addition to individuals, the tribunal had jurisdiction to try organizations. Okay. So the SS, for example, the leadership corps of the German army, the government. Okay. So they had jurisdiction to try them, and then if they were finding them guilty of war crimes or whatever, each person that was member of that organization was found guilty of that crime, provided that was voluntary membership. Because if you have the youth part, for example, the SS, sometimes membership was voluntary, other times wasn't. You know, you were forced to become a member. Okay, so if there was voluntary membership, the organization was defined as a group of people with a common plan, right, to commit crimes within the jurisdiction of the court, right? Voluntary membership, knowledge of the policy of the organization, and of course the commission of these crimes. Okay, so it was individuals plus organizations. What was the jurisdiction, ratione materia of the Nuremberg tribunal? For what kind of crimes, right, it had jurisdiction?
War crimes within war crimes?
Yes, war crimes.
Genocide, Jews, it wasn't developed at that time.
Genocide
Wasn't
was
there.
later developed after the war. But it was included what we call now genocide.
So mass killings was introduced, I think.
Sorry?
Mass killings was the word introduced back then, rather than genocide.
It was crimes against humanity. Okay, so what we call today genocide, I mean, today there's genocide and crimes against humanity because there's a different, the difference is made in the mens rea, right? What differentiates, the acts can be the same. Most of the acts are the same. It's the mens rea that differentiates genocide from crimes against humanity. But at the time it was crimes against humanity, right? And the other crime, the third crime, against peace, right? What we call today aggression, right? So these are the ratione materia jurisdiction of the Nuremberg court. Now, with regard to the Nuremberg tribunal, there are certain issues, well, two main issues, if like that are, of course now it's history, and of course the Nuremberg trials or the Tokyo trials, etc., belong to the mythology of international law, and as mythology, you know, you don't explain, you believe it, all right? So, so now it's, you know, it's not an issue, but at the time it was an issue. So the two main issues were the legality of the establishment of the tribunal, okay? And the second issue was whether it applied existing law or whether it applied law retroactively. And I'm pretty sure you're very good in Latin. So what's the phrase that is used, the Latin phrase?
Next one.
Which was?
It's probably
there in the ICC statute as well, 22 or 24 something.
It's nullum crimen nulla poena sine lege. No crime, no penalty without law. It's the principle of legality, and the non-retroactivity. Okay, so one of the main issues, and as I said at the beginning, you know, as a good lawyer, you go to court and you start challenging the competence of the court, right? You say, you know, you are not, in domestic law you can't do it. It's different, let's say, for international law. In particular, the law has just been established, right? You say, you know, who are you? You know, you have no competence. So one question was about the legality of the establishment of the tribunal. So was any legal basis for the establishment of the tribunal? So, for example, if I put it in kind of different context, you have what is the India's good friends, it's Pakistan, China, and who else? Okay, Pakistan and China. You know, they come together and they say, okay, we establish now a tribunal to try the Indian Prime Minister or whatever crimes. You can invent crimes, it's not difficult. You know, then you would say, okay, on what basis? You have this power, okay? So in that case, one of the first things the German, the accused, said, you know, what basis you try us? You know, what's the legal basis? Was your establishment lawful? Okay. Was it lawful? As I said, it's mythology, but I think it's good because then to know, because then if we do the ICTY, etc., it's again the same.
So I think the Germans themselves agree to the fact that they'll try our program. So the consent part, which is one of the most important factors, was there in itself, that the country itself consented their subjects to be tried.
Is it German or Japan? The Germans, one of the first things they did was to challenge the lawfulness of the establishment of the tribunals. So,
there was a violation of the Treaty of Versailles as well, because that was one of the reasons that they said the tribunal was legitimately formed, because it had placed an onus on Germany not to. There was a limitation on the armed forces that was supposed to apply. So there was a violation of that. Secondly, that the trial that was mentioned in Article 234, the reparations were not fulfilled as well. So that formed the basis for the trials as well.
okay. Yeah, whether, you know, other states can do that to you is a big question mark. There are, if you like, two justifications, of course, you know, to be debated, but the way the court or legal commentators try to explain the lawfulness of the establishment of tribunal. One is the law of occupation, and mentioned that. If you have the occupier has the power to try people for crimes or international crimes, violations of the laws of war, etc. So these four states were occupiers. Of course, they could have done it individually. France could have tried those within its sector, the area that occupied, the UK, US, etc., individually, or they can do it together by creating a tribunal. And then, of course, other states will become parties, etc. So that's one justification, the law of occupation, which is standard law, 1907, Hague Conventions, etc. It existed. Now, the question was whether you can, and that relates as well to the next question of non-retroactivity, whether you can try for crimes that perhaps do not exist. Now, the other justification, whether the occupier can go as far as to create a new tribunal, right? You can use existing tribunals that there are already there and try people for crimes within the jurisdiction, or whether you can go even harder than that to create a new tribunal. The justification for that is, again, is Latin, and I'm pretty sure now you'll be familiar with Latin, is debillatio, D-E-B-E-L-L-A-T-I-O. Debillatio, which means if you have the collapse of the state, okay, and Germany collapsed, Hitler committed suicide, there was no power, etc. The occupier plays the role of the government of the state, and as any government, they can create new law. Okay. So either you have the law of occupation with a question mark as to whether you can go as far as to create a new tribunal. If you go to debillatio and the total collapse of the state, then the occupier can act as the government of the state and can create tribunals, new law, etc. Right? So that's the justification. Now, one of your colleagues mentioned the consent, whether the state gave the consent. That had to do with the Tokyo trial, because for Tokyo, there was a surrender of Japan, signed on behalf of the Emperor and General MacArthur, etc. Okay, and it was a provision of the surrender that there would be these trials. Okay, so for the Tokyo trials, you can say that the Japan gave its consent, right? But not for the Nuremberg trials. Now, the other major question, of course, was about the principle of legality and the non-retroactivity. And that was also in relation to the Tokyo tribunals. But the Germans said that, okay, you try, in particular with the crime against peace and the crimes against humanity, right? For war crimes, there were these prohibitions. There was already law, the Hague Law, and then all the law, some of the 1925 Geneva Convention for asphyxiating gases, etc. So there was some law, there were prohibitions, but for aggression, for a war of aggression, they said, what law does exist? And, that is criminalize it. And also for what's called crimes against humanity, which includes what is now called genocide. So, there wasn't any law about that. So these were the main issues. So how did the tribunal deal with the issues? Of course, if the tribunal was to say, you're right, then that would be the end of the case. So they had to find, and judges, often do that. They can not invent, but take existing principles and then interpret them to different contexts, and then they can come up with a solution. So the tribunal kind of took a normative approach with regard to whether it is criminalized, said that if there are prohibitions, and in a sense expressed in a very clear terms that there are prohibitions. So there was the 1928 Kellogg-Briand Pact, which was prohibited war, and there were the prohibitions in the Hague Conventions, etc. So what the tribunal said is that you would expect, or it is foreseeable, right, that the next step would be to have a criminal punishment. Okay, so if there's a clear prohibition, okay, and also talks about, you know, the individualization of the prohibition, is the soldier should not do this or the other stuff, etc. Then it is a kind of foreseeable to criminalize. Okay, so it was the normative. Okay, if there's a prohibition, there's ought to be a criminal punishment as well, right? Normative approach. And also with regard to the principle of legality, they took a very, they said it's a principle of justice, okay? And it would be, what is the aim of the principle of legality? I mean, why do we have the principle of legality? This, the Latin one, the nullum crimen, etc. What is the aim of the principle of legality? Why do we have it?
To make sure whoever's being prosecuted is aware of standards of conduct. To make sure that whoever's being prosecuted was prior aware of standards of conduct.
Yes. It's to protect individuals against the power of the state. Because otherwise the state, you know, can prosecute, just leave the room here, and then they can prosecute you for whatever. All right? So it's to protect individuals against the power of the state, or the power of the collectivity. You know, people can get together. It's primitive justice. You know, people can get together and say, okay, you know, if you are responsible for something, you know, we take action against you. The other thing, you know, the other goal, however, is that there may be certain sudden community interests, right? There's outcry about something, right? And the law hasn't dealt with it properly, there's a gap, etc., right? So people are, you know, shouting or asking for justice to be done, right? So to some extent, you have to, you know, deal with the collective interest than with the individual interest, right? So, for example, you have, I don't know, there's no law about pedophiles or child rapists or whatever, okay? And then things happen, and you see, you know, these newspapers are writing, people, you know, there's all this moral outrage, etc. So something needs to be done, right? So even if there's law, there isn't any law, then something needs to be done, okay? So it's between, you have to have a balance between these two. So they said, the tribunal said that it's a principle of justice. So, so it would be more unjust if you don't try them than if you try them, even if there isn't a proper provision, etc., to try them, right? Now, this principle of justice, or the principle of legality, was also applied in, you know, after the fall of the Berlin Wall, 1989, in Berlin, East Germany. Perhaps you are aware that there were the guards, that they were actually, they could shoot if someone was trying to escape, they could shoot and kill them. So after the collapse of the wall, then they were tried. The guards, there's a trial of the guards. So the people said that we were just, that was the law in Germany. Okay. The law said that, you know, if someone tries to escape, we just shoot them. We didn't do anything unlawful. Now you're coming and you say that, okay, it was against human rights, it was against this or the other stuff, etc. So you apply law retroactively, right? So the justification of the German law was that the principle of legality applies within just states. If you are a just state, then the principle applies. Now, if there is an unjust state, then you know a new law, just law, needs to apply, right? In order to compensate for the injustices of the previous law. Well, whether this is convincing or not, I don't know, but this is some of the justifications. And your fellow national, the judge at the Tokyo tribunals was very, if you like, I could say, in his dissenting opinion, criticized the tribunal for applying law that didn't exist, violated the principle of legality, and for him, everyone should have been acquitted. Now, if I put it to you now that all the Japanese major war criminals should have been acquitted, I'm pretty sure you would not be very happy, or you may feel uncomfortable. I don't know. I'm just kind of thinking that it doesn't sound, you know, good. That you know you commit all these crimes and then you are acquitted. But that was one of the arguments. Again, with other arguments, whether you know well, one of the arguments is a French word "tout quoque," that you did the same thing, so you tried me for something, whereas you have done the same thing, so I'll be trying, etc. So there's a lot of different reasons for the Indian judge to dissent from the Tokyo tribunal. Now, are these tribunals? They went through all these things, and of course they found certain people guilty, etc. Do you think there are a good precedent? Was it something good, bad to have these trials? Did it contribute to the development of international law?
Now, please, the state heads cannot say that there didn't exist any law prior, like that they can't be attributed to, or they can't be convicted of. So they have a precedent which they can refer while they conduct themselves, or at least go to war.
Okay. Yes.
Sir, as you said before, states are reluctant to take up responsibility for any form of criminal actions, and having such trials will go a long way in according responsibility to states which are actually in the wrong for committing acts of internationally wrongful acts.
So, but the tribunals were about individuals, were not about states.
So, but then if the individual gets some sort of, if the individuals are put on trial for any reason, then it definitely serves as some sort of a deterrent for the future.
Yes. So, is it the deterrence part?
So, a different point, but I think in terms of access to justice, when you put individuals to trial, then say for instances where you can't, where the states refuse to take up certain claims, the individuals who are victims still have a source where they can seek justice. They are not left void of justice. So in terms of that, the trials have set a really good precedent.
Yes. Who thinks that it was a waste of time and money?
But at least it was a bad precedent as far as retrospective application of criminal laws are concerned, which are not done anyway, with the exception of this. And now that we have a permanent court which does not apply international criminal law retrospectively, it looks a bit bad. But then somewhere a start had to be made.
Yeah.
So I think there was a vacuum at that time for international law to have any jurisprudence. So it was fine in that specific instance. But otherwise it sets a bad precedent because there's no specificity for law, especially for the person who's defending such a trial. So I think it's unfair and it's just a crucifixion of any person who's been accused of such.
But don't you think that the way they interpreted the law, then, through the interpretation, etc., that provide a kind of more specificity in the law, so it led to the crystallization. So the initial thing may not have been there, right? But then, they specified, interpreted, defined it better. So you can see it this way. There's another with the guy.
So, why can't they use the same argument of prohibitions being a reasonable indicator of it being a crime for even this, rather than relying on a subjective principle like it will be more unjust to not try them rather than trying them? So they should have used the same argument that prohibitions are foreseeable as crime, will be seen as crimes, rather than going for the subjective.
Okay.
I was going to say that it's essentially setting rather poor precedent, because even when they're interpreting, what they're interpreting isn't law. Their process of interpretation actually creates it.
Yes.
So although that might be counterproductive in broader interest of justice, in the long term it does set a framework.
But yes, I mean, the different arguments, but you have to put it also in the context of the international law. International law does not have this kind of legislative body. I mean, what it has is the domestic system. Okay, there's a new need. So what you do, you go to the parliament, etc. You can have new legislation, etc. Now, at the international level, you don't have this kind of mechanism, centralized legislative body. Of course, you can have states coming together and legislating, but of course, that's not always very easy to do that. So to some extent, international law, and it may sound to some ears, and international law as well, but I take also a very realistic view of international law. Sometimes international law appears out of the blue. There's nothing. It appears. Continental shelf, for example, law of the sea. Someone, Truman said it, that was it. It didn't exist before that. And sometimes the law, or international law, appears through breaches of the law. Okay, so you start a new kind of trend, if you like, which appears to be at the beginning a breach of an existing rule, right? And then through what appears to be breach, and then it's followed, etc. Then you have the development of a new rule, etc. So someone has to put it, in the context of international law as well, and the whole. Sometimes, some element of morality that exists at the international level. I'm not saying it's full morality, but there is some elements of morality. It's also very important because what we know about the Second World War, right, comes through the process, say in Nuremberg, right? So the whole deterrence thing, the whole educational part of trials, etc., is what we know through the trials. Okay, they did certain things, and we know. And also it has to do with legal culture. Western legal culture is you believe in the authority of the courts. You believe that the judges are impartial, right? So you believe that if the court said it, it must be true, right? So that's a good thing. But the problem would be if what we know about the cause of the war or what happened or how to be prevented comes from the trials. Because trials are trials, whereas history is history, and it takes a lot of other variables to explain causes, effects, what can be done, right? Courts have a very limited, in that sense, that they can establish facts, yes, but they cannot explain the big picture, why things happened, or how they should be prevented. So there are all these things, so yes, there's a lot of good stuff, but also it's not good to concentrate only on them as the ultimate war, as to the Second World War, etc. Now, I have another quarter of an hour. I suggest that perhaps there are two issues. One I wanted to discuss is the sources of international criminal law. Have you read the Full-DGA case, which is in your handout from the ICTY? Have you read this case? No? All right. Okay. Now, so I suggest then, have you read any of the cases? I mean, you just go to the website, right? And you find the name. I think if you click it, immediately, have you read them? No? I think if you click at the, the case, immediately redirects you to the case. And well, you can read this paragraph, say from the Full-DGA case, trial number 2 from the ICTY, paragraphs 165 to 185, and it's quite interesting. It's about the sources of international criminal law and how the court, the question in that case is whether it's about the definition of rape in international law and whether oral penetration is within the definition of rape. And you see how the court goes from different sources, try to find how you define rape in international law. So I would say that you read it before going to bed. You can be ready for tomorrow. And then we discuss it tomorrow, so we go through the court's reasoning and how to use the sources. So I can finish today by discussing this state responsibility and the relationship between state responsibility and individual criminal responsibility. Have you read the Bosnia genocide case? All right. I think it would be good if you are to prepare for the seminar. You can read, the material, the literature, etc. But from the cases, at least the ones with the asterisks, read it. So for tomorrow, you read for sure the Tadic case, which is in seminar 2. Okay. Okay. 1995 decision appealed to. So please read it because we're going to go through the case as to the lawfulness of the establishment of the tribunal, right? And you read also the Prodigia case, right? In addition to anything else you have known. Now, with regard to the state responsibility, the relationship between state responsibility and individual criminal responsibility, states may have obligations. For example, there's an obligation for the state to prevent and punish genocide. Now, the state does not have an obligation not to commit genocide. Right? So, how can a state commit genocide? Through its organs, right? Soldiers or whatever, right? They go, they kill, I don't know, half of the West Bengalis, for example, if there's an ethnic group. Okay, that's genocide, right? But the state does not have an obligation not to commit genocide. So if the state goes and punishes, well, does not prevent because he did it, but goes and punishes people, that's okay, right? I say to my soldiers, go and kill, and then I'm going to punish you. I'm all right under the Genocide Convention, right? So there's a problem there. And that was a question that was raised in relation to the, have you heard of the Srebrenica genocide in Yugoslavia, where kind of 17 to 20,000 Bosnian Muslims were massacred by Serbs. Okay, so they were put in buses or whatever. They were, it was mainly men actually. So the women and the children, they were separated, and the rest, not 7,000 to 8,000. They were put in buses, moved to a place, and then they were executed, etc. So that was the big issue, the genocide. So the question was whether Yugoslavia or Serbia was responsible for not preventing or for not punishing genocide, but the question was whether it was responsible for committing genocide as well. Okay, so that went to the International Court of Justice because that's about state responsibility. Okay, criminal courts do not have jurisdiction over states; they have over individuals. The ICJ has over states. So it went to the ICJ, and the court said that, of course, it would be absurd to say that a state has responsibility to prevent and punish, but not commit genocide. So interpreted a kind of dynamic interpretation, but also, if you like, reasonable interpretation of the law that the state indeed has an obligation not to commit itself genocide, in addition to prevent and to punish genocide. Okay. But the question then is how you can say that a state commits genocide. Okay, because the state is an abstract entity, right? Now, to commit genocide, you need to have actus reus and mens rea, right? So the court related the state responsibility and individual criminal responsibility. And what it said is that if organs of the state, or those under the control of the state, commit genocide because they have the actus reus and the mens rea, right, then the actus reus and the mens rea of, say, the organs of the state is attributed to the state, so the state commits genocide. Okay. So that's the way it interpreted the law. And also, there's an obligation for the state not to be complicit in genocide. So, to punish complicity in genocide, that's individual criminal responsibility, right? There is a state, part of the state responsibility is not to aid someone to commit a violation of international law. So what the court did was that took the criminal law of complicity and the state responsibility rule of aiding and abetting and said they are the same. So if an organ of the state has helped, assisted, provided assistance to someone to commit genocide, and it satisfied the criminal law, the criminal law provisions for that, for complicity, knowledge, substantive contribution to the commission of the crime, etc., then we attribute this to the state because aiding and abetting by the state needs to have aid or assistance, help, knowledge, and knowledge that the other state is going to commit a violation. Okay. So in the genocide case, the ICJ took the individual criminal responsibility, and if that was done by an organ of a state or someone under the control of the state, it attributed to the state, and then they said that the state committed genocide, or the state then committed crimes against humanity, etc. Okay. The problem with that, of course, is that the ICJ is not a criminal court. For that case, the court relied on the jurisprudence of the ICTY, the Yugoslav Criminal Tribunal, right? So you have the case law, okay, it was ready. But if you don't have a criminal tribunal, right, how you can prove it? The ICJ then needs to prove the criminal law, the individual criminal responsibility. But the ICJ does not have jurisdiction over individuals. The ICJ does not, is not a criminal court. It doesn't have the competence and it doesn't have the skills to do that, right? So it will be kind of prima facie finding that, you know, there's this crime has been committed and then attribute it to the state, which can cause problems, because to say that the state has committed genocide is a big thing. And if you base this thing on a prima facie finding that an individual, an organ of the state has committed, it's not enough. But, you know, it's criminal law. You have to, criminal law, you don't prove it on a prima facie, you need to have evidence, right? Another problem is that some of these individuals may have been acquitted because of defenses. Okay. So yes, it appears that I have committed genocide, but I acted under duress. That's a defense. It's mitigation, or self-defense, or something else. Or there was a mistake of law, or something, right? So individuals, they may have been acquitted, may have been mitigated, etc. So to kind of apply, take the individual criminal responsibility and attach it to the state, if it is an organ of the state, it's not always, you know, the results are not always good results. So that's one way of dealing with the issue. Another way of dealing with the issue, okay, is to prove that the government, okay, had satisfied the criteria for the commission of the crime. And that was how, you know, in Darfur, in Sudan, you know the situation, there's genocide in Darfur in Sudan. So there was the Commission of Inquiry that said there was genocide in Darfur. So the Commission took the government and its policies and tried to find out whether they had the actus reus, right, that there were policies that said, you know, you commit genocide, and also the mens rea. So then you take the actus reus and the mens rea of the government and you attribute it to the state. So if your government had genocidal intent and committed genocide through its orders, etc., then the state is responsible. With this thing, that's to some extent easier because you don't have to prove the mens rea and actus reus for each individual. And how many individuals you need to find? You know, if one organ of the state committed, doesn't mean that the state is responsible for genocide. Do you need to find more? And how many? And to find it on an individual basis is more difficult. Okay, because it should be the mens rea and actus reus for each and every individual. If you go to the state, to the government, it's easier. Irrespective of what individuals, what mens rea they had, if the government had the genocidal intent and kind of the actus reus things were happening, then it's easier. But then how you find the intent of the government? I don't think there's any government insane to say that you know you commit genocide. No one says that, right? They say the opposite actually, and then they go to genocide. So how you find it in the first place, and what is the government? Is it the cabinet? Is it the government? Because the cabinet is more limited, the government is wider, etc. So again, there are problems. Okay, so we are where we are now. So there are two approaches. One is individual, attaching individual responsibility to the state and saying that the state is responsible. And the other is government, attaching the government actus reus and mens rea to the state and saying that the state is responsible. The choice is yours at the end of the day. So I don't think there's any clear-cut answer to that. Okay. Are there any? I'll finish here. But are there any questions? Something you want to discuss? Okay, so then for tomorrow, please read these cases, and then we discuss